C Property Services, making your real estate dream a reality.
Welcome everyone to this, our third episode of Real Estatically Speaking and More. I'm your host, Karen Koch, and with me this evening is a very special guest, Miss Rudine Speid. And of course, you would have all seen the flyers, as to what she's going to speak about and all of that. So I'll get to that in a few minutes. Okay? And so tonight, we're happy to be here. We're happy that you could be with us, those of you are on. I'm going to ask you please just to type your name in the chat. Listen keenly, because tonight you are in for a treat. Surprises and prizes. So make sure that you are listening keenly. And if you are one of those who attended all 3 episodes, then I would love for you to place your name in the chat. All right. So tonight's quote is, buying real estate is not only the best way, the quickest way, the safest way, but the only way to become wealthy. And this was written by a gentleman named Marshall Field. All right, everyone. I am going to introduce our special guest, Miss Rudine Speid. She's an attorney at law. She's the owner of Speid Law, and she's also a realtor associate, and she's attached with KMC Property Services. Ladies and gentlemen, please make welcome Miss Rudine Speid, and she will just elaborate a little more and tell us a little more about herself when she comes on screen.
Hi, good night everyone. Thanks for having me, Karen.
You're welcome.
Alright, so I guess just a little summary. I am a practitioner, a civil practitioner. It means I don't do any criminal matters. I've been in practice for 9 years and counting. Not sure what else we need to know. I guess when the question and answer starts up, then I can get a bit more detail depending on what our viewers would like to hear.
All right, so I'll just go right into our question and answer. Miss Speid, do you specialize in any other aspect of law, or are you a general practitioner?
In terms of specializing, I do a lot of conveyancing, meaning buying and selling of property. We also do a lot of divorces. The probate industry has boomed. There are a lot of persons doing wills now. So we do a lot of those matters as well.
Okay, great. My next question to you. What does the closing cost entail?
All right, so your closing costs, if you're a purchaser, it's not really that much. You have the stamp duty, which is a fee that's paid to the government. This is $2,500, so that's the easy one. There is also the registration fee. It's the purchasers or the seller's portion is 0.25% of the sale price. There is also what we call a letters of possession fee. Some attorneys will say a miscellaneous fee. That is usually dependent on the attorney. The industry standard is about $20,000 to be shared between the purchaser and the vendor. What this allows you to do is to get those letters that you would take to the utility companies to have your electricity placed in your name, the water placed in your name, and for your name to be added to the tax roll. The only other thing you might have at the end of closing is the rest of your attorney's fees.
Okay, thank you. Which tenancy would you recommend for 2 or more purchasers?
Okay, well, that actually depends on the individual purchasers. And I would say every situation is different. So there are 2 types of tenancies that you can hold a property in. You have joint tenants and you have tenants in common. Joint tenants deals with the issue of survivorship. So my easiest way to explain it to my clients is whoever dies last gets everything. So that means that if there are 2 persons or 3 persons on the title, once one person passes, their share goes to the next person and so forth. So whoever is the last man standing gets it all. There is also those tenancies are usually more common between spouses. Because it allows you to avoid the issue of paying certain taxes, and it makes a transfer much easier for you to be able to deal with the property after the passing of the other title holder. The other option is tenants in common, and what that means is that each title holder will always hold a portion of the property. So once you pass, your interest goes to your estate as opposed to the other title holder. So it means that you can either will it or it will go down through the usual administration line. Now, the beauty about tenants in common is that you can decide how much interest each person holds in the property. With joint tenants, no matter what, you each hold a 50-50% interest. So with tenants in common, if it's 2 persons, for example, you can still do 50-50. Or you can do 60-40, 70-30, 80-20, and so on, whatever you decide to do. If it's 3 of you, then again, you can split it in 3 equally, or you can give different shares based on maybe the contribution of each person towards a purchase. So if you put in $10 and the property is worth $50, then your share will be adjusted accordingly. So it really depends on the particular situation. So it's not just clear cut, just to pick one. You really have to think about what you want to do.
Okay. Why does a seller need an attorney?
Sure. Well, both parties need an attorney, but especially for the seller, the sale is a very involved process, especially if you have a mortgage on the property. So financial institutions, if you try to do a sale matter on your own and there's a mortgage on it, they're not going to pay you too much mind, because they have to receive assurances that they will get the money that is due to them. So for instance, in order for the purchaser's interest to be noted on the title, the mortgage holder has to release the title to an attorney, which means they remove their interest before they even get paid. So that's not something they'll trust to an individual. Sorry, that's one. The selling of a process also has very involved stages. The preparing of the sale documents is very important. Some persons take it for granted that a sale agreement is literally just saying, I agree to sell to someone for a fixed price. There's a lot more involved in the process than that. Sorry, your attorney probably wouldn't sit down and explain it all to you, but for selling a property, there are things we have to ensure are in place in terms of the title. We have to do searches to make sure that there are no caveats lodged against the property, which is the same thing for a buyer. We have to make sure that everything can actually be sold. So for instance, you have a lot of persons who they'll have a property with somebody else, the person dies, and they get up tomorrow, they try to sell it. It's not as simple as that. So you have to have an attorney to actually take you through the entire process, because it's very involved. And it's very cumbersome and a bit of a headache if you're not experienced in the actual field. So we actually need the attorney to protect your interests, to ensure that you get the sums that are due to you, to ensure that you get it in as much a timely manner as possible. So it's not something you can really do alone. Just the submitting of documents to the government can be a headache. So you actually need someone experienced to actually hold your hand and take you through the process. For me, I tell my clients, all you need to do, you sign a sale agreement, you transfer, and you wait on your money. But they don't understand there's so much involved in this process that if they actually got into it, they'd probably give up. So when a buyer gets an agreement for sale, this is a short agreement for sale, might be a 6-page document. Someone has to go through that document, because in the legal field, one word can make a difference. A lot of persons don't understand that if they don't honor their obligations under a sale agreement, they run the risk of forfeiting, as in losing their entire deposit. So imagine you paid a deposit of $1 million, and because you didn't understand what you signed on to, you've lost that $1 million just outright. Not illegally, not a backhand deal or anything. There are many obligations under a sale agreement that the purchaser has to deal with, and they need to understand what it is that those things are. There are issues in terms of timeline for presentation of documents, getting surveyor's report, valuation reports. The attorney also has to check to ensure that what is being sold is a valid piece of property. We've had several issues, in Jamaica and across the globe, where persons have bought land that are in the middle of the ocean, as in the land doesn't exist. But they were presented with a title and thought it was fine. And so you do need an attorney to protect your interests. Make sure that you're actually purchasing what you aim to purchase. Make sure that you're actually purchasing it for fair value. Make sure that when you're purchasing, there are no issues with the property. So I've had matters come in where the name on the title is not the name on the sales agreement, but I know what to do to address issues like that. A purchaser wouldn't necessarily know the starting point. There are persons who get documents and don't read, and you sign away, and as Jamaicans say, you sign away your rights. So you do need someone to hold your hand through the process, explain to you all these legal jargons, explain things to you so that you're actually safe and secure in your purchase. Ensure that when your purchase is finished, that everything that needs to be done is done. So the taxes are sorted out, the water bill is sorted out, that you can actually get your keys and move into your property and be comfortable where that's concerned.
What is a mortgage deed?
Alright, so a mortgage deed is what your financial, and your as in the purchaser, your financial institution will prepare to outline the terms and conditions of your mortgage. This is what secures the bank, so to speak, or NHT, to lend you the money, and it has conditions in terms of how you will repay, your interest rate, your monthly payments, things like that. The mortgage deed is very important because a lot of people don't understand, and this is why lawyers are very important. A lot of people don't understand when they sign these mortgage deeds what their obligations are. So a mortgage deed will have terms where they'll say to you, you're not allowed to do anything to the property without their permission. So for instance, if you want to add on to the property, these deeds will tell you that you really need to consult with the mortgage company first before you make these additions to the property. The mortgage deeds will explain to you that the mortgage company has the right to come to the property, look at it, see if there are anything wrong with it, come in, require you to fix it, or fix it themselves and then add it to your mortgage. These deeds explain in terms of insurance purposes that your buildings have to be insured. They have to be the recipient. So this mortgage deed is a very involved document. Also one of those very long documents with a lot of legal jargons that is good to have someone explain to you what your obligations are. So the purpose of the deed really is like a contract between you and your financial institution to put their name on the title, lend you the money, and secure the repayment of their principal and interest.
What is the administration of a will?
Alright, so when there's a will involved, we normally say we probate the will. The administration we usually refer to when the person has passed, when the person has passed and they don't actually have a will. So in order for you to have the will probated, what it means is that you have to make an application to the Supreme Court of Jamaica to determine that the will is valid and that whoever is listed as executor, or executors will actually be allowed to deal with the property of the deceased person. So normally the will outline who is in charge of the estate. So it normally say John Brown is my executor. I empower him to do certain things. I empower him to pay my funeral expenses. I empower him to distribute my assets in the manner that I think fit. Now, the application again is one of those things that you really need an attorney to do because it's not a simple process. When you take a will into an attorney, the first thing they have to do is to check that the will is in keeping with the rules of making a will. So you have will forms in bookstores that persons will fill out, but if it's not done properly, it's really of no effect. So you can use a will form if you have guidance as to what to do, but we really do recommend that you get an attorney to do those wills for you. So in order to prepare the will, we apply to the court for the court to determine that the will is valid and to appoint a particular person in charge of your estate. Now, once this person receives a grant of probate, it means with that one single sheet of paper, they can go anywhere in the island of Jamaica and take over any asset that is in your name or in which you have an interest, and then give it to whoever the will indicates that they need to give it to.
Okay, so basically you would have answered
all
part B and part C by your answer.
Yes, and yes, we do offer the service of writing the will, and we always encourage persons, because sometimes you will have a property and Jamaicans tend to do this thing where they said, this is my house, but then the house is in your sister's name. So they'll say it's my house because they paid for it, but legally the house is your sister's. So it's important that you actually come into us, show us what you have, and we'll explain to you what you need to do to get your house in order.
What advice would you give to a buyer who wishes to share attorney with the vendor?
Okay, well, first of all, don't do it. It is actually against our ethics to do that. But as a practice, for me personally, I don't recommend it, because here's a problem you have. When you go to an attorney, that's, as people say, this is my lawyer. Yeah? You're selling, this is your lawyer. You're buying, it's the same lawyer. If you have a problem, who does the lawyer act in the best interest of? So, the attorney has to pick a side, and you really don't want to end up on the losing side. So you need to have someone who is fighting for you only, and doesn't have a conflict of interest with any other party in the sale. I have a lot of family members, one family member selling to the other, who want to come to me and use me to act for both parties. I don't do it. Because things can crop up really easily. There's a breach on the property, there's an issue with the purchaser getting their financing. I have to advise a certain way, and my advice for a purchaser would not be the same as my advice for a vendor. So I never ever recommend it. And in fact, a lot of persons would want to purchase, as purchase would want to go without an attorney. Again, I can't stress it enough, don't do it. You really need to have someone in your corner, and that's what your lawyer is for. So, it's cheaper, some persons think, to use the same attorney, but, as we say, sometimes the cheapest become the dearest. Just don't do it.
What is your role in the correction of a breach on a property and the potential cost?
Okay. Well, the first thing that persons need to understand is there are two types of breaches, as we casually say. You can have a breach that is within the boundaries of the property, as in within the four walls of the property, right? If you have a breach like that, your sale can continue or your purchase can continue, because what will be required is that your attorney can give an undertaking to your financial institution that they'll rectify the breach, and then the matter can go on. The other breach that's a problem is where there's an encroachment, which means either a part of the building or the wall for the property has gone onto someone else's land, or vice versa. Once there's an encroachment, your sale falls through completely, because the mortgage company can't control what a third party has done. So we try to avoid encroachment as much as possible, because it really does affect the sale. There's really nothing to go on unless it's a cash purchase and they choose to take the property with a breach, but then somebody has to fix it at some point. So I really don't recommend. because in order to rectify a breach, there has to be either, well, depending on what it is. So say your wall is over the boundary, you can hit the wall down and rebuild it. That's the cost you have to worry about. But say the breach is because the building is too close to the boundary. Hitting it off might not be the most sensible thing to do or practical thing to do. So what it means is that we actually have to apply to the Supreme Court for the title to be amended, which can be a costly process. You have to have a plan redrawn to fit in this extension. There are attorney's fees involved. There are updating of titles fees involved. Depending on the extent of the breach, this can run you between $300,000 to $500,000.
Wow.
Yes. And so, and I should add, Karen, and this is why it's important to have an attorney, because as a purchaser, parties are free to agree to whatever they want to do. And sometimes a purchaser will say, you know what, I'll fix the breach, not really appreciating the cost involved in doing it. And so, you really have to sit down with your counsel and discuss what your options are and what really makes sense for you. All right, so what happens is that when you apply to your financial institution for a loan, they provide you with what they call a letter of commitment, which is your promise ring. Let's look at it that way, or your engagement ring. So they'll give you this letter to say, yes, I will give you a particular sum of money towards the purchase of your property. This applies to the purchasers only, by the way. So your institution will say, yes, I'll commit to paying $10 towards the purchase of this property. And the commitment letter will outline what your monthly mortgage is going to be and details like that. Now, the thing with the letter of the commitment is that just with your engagement ring, the bank can change their mind and say they're not going to go ahead with the transaction. Normally, this will only happen if during their investigations, they discover something maybe fraudulent with your application, or having done a better look at the property, they realize there might be structural issues where the property won't outlast the life of the loan. So for instance, the building might be in such a disrepair that, based on a structural engineer report, it doesn't seem that it'll last more than 30 years, but then you're taking a loan that's going to take you 50 years. So, the letter of commitment is revocable. The letter of undertaking now is when you go to the altar and you get married. So once a bank gives you this letter of undertaking, this is as good as cash in hand, as I like to say. It's not something that they can just take back because they've said, I will do this. And so once you get that letter of undertaking as a purchaser, you're comfortable. It's just a matter of waiting. As a vendor, your money is on its way. So that's really the difference, the best way to explain it. So the undertaking is the actual wedding itself.
At what stage of the buying process is each needed or required?
Okay, well, it actually depends on your agreement for sale. The typical sale takes about 120 days. But you have some matters that want it shut down in 90 days. If it's a cash sale, then we hit 45 days. So if it's a 90-day sale, your letter of commitment is usually required within about 30 to 45 days of signing the sales agreement. If it's a 120-day sale, we usually request that within 60 days of the agreement for sale date. If it's for as it relates to letter of undertaking, if it's a 90-day sale, we usually want that by about 60 days into the agreement. If it's a 120-day sale, we usually want that within 90 days of the agreement for sale date. Now, the thing about it is when you're using financial institutions, especially with COVID, and especially sometimes with the government financial institutions, they take a bit more time. So we always try to do a 120-day sale, which is the average. And so it would mean that your commitment is due within 60 days and your undertaking is due within 90 days. In order to get the letter of commitment, though, the purchaser has to do a lot of legwork in terms of getting their documents together to get to their financial institution. But once you get the letter of commitment, there's usually nothing much for you to do for the undertaking to be issued. Normally, then you'd probably just need to sign the mortgage deed, stuff like that, and you'll get your undertaking.
All right. I want to thank you so much for, such a very insightful and in-depth explanation, of what you do, and from now on, I guess most of us will be a little more literate concerning legal matters.
Yes.
All right. So, thank you so much, Ms. Speid.
Tune into our live stream, Real Estatically Speaking, with yours truly every second and fourth Friday as of November 2021. You can contact us at the information on screen.